Can you just take me back to that time? Because I'm interested in the sort of the human aspect of this story. I mean, did you have sleepless nights? Were you able to eat? Were you able to function? Like, what was that period like? Just that Tuesday to Friday, if you remember.
Well, that Friday to Tuesday that was a lot more troubling than maybe some of the earlier nights. But some of the anger that's on those tapes, when you hear, I've heard myself on those tapes that have been played publicly. And by the way, Megyn, let me just say this. You talk about hundreds of hours of tapes, and you're right, but they only played 1% of them. And to this day, I can't get them to play all those tapes. They wouldn't even allow me to play them in court to defend myself. And I suspect we'll probably talk more about the case. But I wanted every one of those tapes heard. I wanted the full context of those conversations heard because they would show the real truth.
Okay, but let me ask you something. I heard you say that a million times, and we can get into the tapes. And I have some of the more infamous excerpts. But
right,
if that and I didn't read every single moment of the trial transcript or anything like that. But in general, I did practice law for 10 years, and if you had something that was exculpatory on those tapes, meaning led to a finding of innocence, your lawyers would have played them. Your lawyers would have been able to get them in. The court would have allowed them in for completeness, if nothing else.
Right.
You're telling me that there's some magic bullet in those tapes that never got played? Well, then your lawyers are terrible, and you should have filed an appeal based on ineffective assistance of counsel.
Okay, everything you just said there is absolutely right, except one thing. We asked for the tapes to be played at both trials, especially the second trial. I agreed to testify at the second trial on condition that we could play the tapes. And the judge said, yes, we could play the tapes to corroborate my testimony, because I foresaw the real likely possibility that if I got up and testified to a set of conversations that I had, and if those tapes weren't there, the prosecutor would do exactly what he did, and that is lie to the jury and tell the jury to go back to the jury room and listen to the tapes to see whether or not it corroborates with what I'm saying. The fact is, it's all in the court record. And the appellate court shockingly whitewashed it and didn't even address the issue that they wouldn't allow me to play those tapes. And they would not allow me to play those tapes. You're right. There is a thing called the rule of completeness. This is effing gold, and I'm not giving it up for nothing. They will never allow me to play the rest of that conversation. They took snippets of conversations out of context and pieced them together. And even by themselves, those things don't constitute crimes. You
know what, though? But let's just jump to cut to the chase. That your alleged attempt to sell the vacant Obama Senate seat, is not something that you were ultimately convicted of. I mean, that conviction didn't stand. That one was thrown out. So if that's the thing that was your tapes were going to exonerate you on, la point is moot.
Except that I was in prison for 4.5 years on that. And I'm still known for that, the so-called sale of the Senate seat. I hope I don't die tomorrow. This is
like a long list of things that you allegedly did wrong. Things that you were convicted of doing wrong. I, too, for a long time thought it was just the attempt to sell the seat. But there's a lot of stuff they said that you did try for an attempted quid pro quo on, and we can go through it.
Correct. Yes. And there was no quid pro quo.
But there was an attempt. That's what you were charged with, attempt.
Right, I know. But in order to have attempt, you have to have evidence of an express quid pro quo. There never was that. In fact,
again, you added the word express. That's not true.
But it is. That's the McCormick case, 1991.
No, I've read McCormick, 1991. That's not what it requires. And I read the Seventh Circuit case, Digesting McCormick, in which you were appealing. And that's not right.
Well, you're the hostess of the show, and you're a lot smarter than I am. But I have to tell you, I know where the line is. When you ask for a campaign contribution and you don't promise or threaten anybody directly in exchange for that, that's legal. That's free speech.
The Seventh Circuit made very clear in looking at your case on your appeal, wink, wink, nod, nod is sufficient. No politician at most wouldn't be dumb enough to be like, you've got to make a $50,000 donation to my campaign tomorrow. And then the day after tomorrow, I will approve the legislation that's going to help your racetrack, sir.
Okay, by the way, but the reality is that's exactly how the system works. So, for example, the big drug companies contribute campaign contributions to United States senators and congressmen while they're voting on their things. Now, as long as there isn't...
Can I just tell you? I don't disagree with that. I don't disagree with that. Keep going.
Right. Are you asking me, is the system a good system? No. Would you argue that it's legal bribery? Yes. I think you can argue that. But the line is very clear. And in 2014, that Citizens United case, the Supreme Court reaffirmed that standard in McCormick, saying the only way you would limit the only compelling interest to limit free speech, because that's what fundraising is. Mm-hmm. They call it free speech, is so-called quid pro quo corruption. Knowing where the line was, we never promised anything. We never threatened anybody. They upheld 3 fundraising requests where I received nothing. after they vacated the
right.
Senate.
But it was an attempt. That you always say that I didn't get any money, and I agree that based on what I've read, you didn't. But that's not relevant. That's a dodge. That's a red herring. If you attempted to get things, you attempted to get money in your coffers in exchange for your public duties, and that is illegal. And I'm not going to dispute with you that you were singled out. And that a lot of people, and your example of the drug companies is a great one, very apt. They do buy favors all the time from politicians who are also corrupt. But that doesn't excuse what you did.
Megyn, I think the world of it, and I want to talk, I hope we can, as this unfolds.
Of course, we can disagree. I don't hold it against you. I have no personal stake in this. I'm just giving you the way I see it as a lawyer.
Well, yes, but again, the law is you can ask for campaign contributions while something's pending, before something's pending, or after something's pending, so long as you never promise anything or threaten anybody. I knew where that line was. I didn't cross it. They convicted me by moving the line at a second trial. The appellate court upheld it. I believe because the political consequences were so significant, because someone's going down. Either I'm going down or those federal prosecutors, those corrupt federal prosecutors who did to me what they tried to do to President Trump, they would go down because they hijacked a governor twice elected by the people. That's my firm belief. And I know that, the trial, if you were there and saw it, if you read our appellate brief, and I wouldn't ask you to do it, you have too much more important things to do. But I knew where the line was. I knew they were chasing me. I wasn't that stupid. And they moved the line, and I ended up going to prison largely because I fought back and I was defiant every step of the way, wouldn't take any deals that were being dangled in front of me.
I mean, I get that's true. And I certainly believe that you did not foresee a conviction. Your behavior backs that up. But I have to be honest with my audience. I think they got you dead to rights. I think you did do it. I think you were singled out. But I mean, having watched a lot of the trial and covered it at the time as an attorney and a journalist when you were going through it, and then buffing back up on the whole case for this interview, they got you. I mean, they got you for attempt. You didn't get the money because you were actually arrested before all the shit could go down. But you were striking deals, and I'll just give a couple of examples. These are a couple cited by the Seventh Circuit. But there was number one, lobbyists for Children Memorial Hospital sought an increase in reimbursement rates for Medicaid patients. That was in your control as the governor, and you said you would approve an extra 8 to 10 million of reimbursements in exchange for a quote campaign contribution of $50,000. And initially you approved that rate increase that they wanted, but then you rescinded it when you were waiting for the contribution. Then you got arrested before any money changed hands. Then there was another situation with the state legislature approving an extension of a program that taxed casinos, and that tax would help racetracks. It was for the benefit of racetracks, which didn't do as well in Illinois. But before you could sign the bill, you attempted to ensure that a guy named John Johnston, who owned interests in two of the racetracks, fulfilled a, quote, $100,000 campaign pledge. And you had intermediaries inform Johnston that the bill would not be signed until your money arrived. And again, you were arrested before you could sign the bill and before he signed the check. Now, that is what the jury so found. Your defense was presented. They rejected it. The jury found that those facts, as I just read them, are true. That's it. That is unlawful behavior under Illinois and federal law. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.